Georgia probate judge Christina Peterson made headlines recently after police body cam reportedly caught her on tape assaulting a police officer. Now, the Georgia Supreme Court has terminated Peterson, who was already under investigation for numerous professional violations. Here we present the Georgia Supreme Court decision in audio format. Citations have been omitted. You can find the written decision by clicking the link in the description. Inquiry concerning Judge Christina Peterson, per curiam. We have explained before that the judiciary's judgment will be obeyed only so long as the public respects it, and that respect will not long survive judges who act in a manner that undermines public confidence in their judgment and integrity. In this case, Douglas County Probate Court Judge Christina Peterson has been charged with a number of violations of the Code of Judicial Conduct, CJC, including a number of violations that the Judicial Qualifications Commission, JQC, says exhibited a pattern of judicial misconduct while in office. The JQC hearing panel found that Judge Peterson violated multiple rules in the CJC and that those violations warrant her removal from the bench. We agree that removal is warranted here. As we explain more below, the hearing panel found that the director proved by clear and convincing evidence 28 of 30 counts, alleging that Judge Peterson violated the CJC and that discipline is authorized under the Georgia Constitution for 20 of those 28 counts. With respect to all 20 of those counts, we conclude that the hearing panel's findings are not clearly erroneous, and we agree with and affirm the hearing panel's conclusion that Judge Peterson's misconduct warrants discipline with respect to 12 of them, because the director met her burden of showing that Judge Peterson's conduct constituted willful misconduct in office or conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. The seriousness of certain of those violations, the pattern of misconduct the director proved by clear and convincing evidence, and the adverse demeanor and credibility determinations the hearing panel made after observing live testimony from Judge Peterson all contribute to the conclusion we reach today. 1. Background and procedural history. Judge Peterson was admitted to the State Bar of Georgia in 2013, and on March 5, 2020, she qualified to run for the office of Judge of the Douglas County Probate Court, and therefore became a judicial candidate for purposes of the CJC. In June 2020, she won a contested primary election. She then won the general election, in which she was unopposed, and she was sworn in for a 4-year term as the Douglas County Probate Court Judge on December 29, 2020. In September 2021, the JQC filed formal charges against Judge Peterson, alleging several violations of the CJC. The JQC amended its charges in February 2022 and again in July 2022, alleging 50 counts of misconduct. The JQC director dismissed 20 counts before and during the final hearing, which was held over the course of 7 days, beginning in September 2023 and concluding in February 2024, leaving 30 counts remaining for the hearing panel's resolution. The hearing panel issued a report and recommendation on March 31, 2024, finding that the director had proven 28 of the 30 counts by clear and convincing evidence, but that discipline was authorized pursuant to the Georgia Constitution for only 20 of those counts. In so doing, the hearing panel concluded that Judge Peterson had violated multiple rules in the CJC and recommended as a sanction that this court remove her from office. Judge Peterson filed a Notice of Exceptions to the report and recommendation, Exceptions, CJQC Rule 24-F, arguing that the director had not sufficiently proven that she committed sanctionable conduct, and the director filed a response to those exceptions. 2. Analysis. As discussed more below, we agree with and affirm the hearing panel's conclusion that Judge Peterson's misconduct with respect to 12 of the 20 counts, counts 13, 28, 30, 35, 37, 39, 40, and 42, at issue here was proven by clear and convincing evidence and warrants discipline. Those counts relate to 4 separate matters, which include Judge Peterson's handling of a criminal contempt matter, counts 31 to 34, certain aspects of her conduct toward county personnel, counts 28 and 30, her conduct during a meeting of her Neighborhood Homeowners Association, HOA, count 13, and her handling of a petition for years' support, counts 35, 37, 39, 40, and 42. We discuss each of these 4 matters in turn below, applying the following analytical framework. First, we review the hearing panel's findings as to Judge Peterson's conduct with respect to each matter. We generally review factual findings by the JQC hearing panel for clear error and defer to the hearing panel's credibility determinations. Judge Peterson's primary argument in her exceptions to the report and recommendation is that the hearing panel's factual findings as to each of the matters at issue are clearly erroneous, because the panel either failed to credit or to expressly mention in its report and recommendation evidence that Judge Peterson says supported different findings. In this respect, Judge Peterson devotes dozens of pages in her exceptions to recounting this other evidence. But we need not and do not detail most of that evidence below. Although Judge Peterson is correct that some of the evidence she notes, if credited by the hearing panel, could have supported different findings, the record in this case does not compel those different findings. To the extent the record contains evidence that could support findings in either direction, the hearing panel was authorized to make the findings that it did. After thoroughly reviewing the record and the parties' briefing, we conclude that the findings the hearing panel made that are material to our ultimate conclusion in this case are not clearly erroneous, and we defer to the findings that the hearing panel made, as outlined below. Second, we consider whether these findings support the hearing panel's conclusions that Judge Peterson's actions, with respect to each matter, amounted to violations of the CJC rules the JQC charged. In considering whether the director has proven violations of the CJC, we employ a clear and convincing proof standard. And we review the hearings panel's legal determinations de novo. As explained below, we agree with the hearing panel's conclusions that Judge Peterson violated multiple rules in the CJC. Third, our review of the hearing panel's findings and conclusions is necessarily conducted through the lens of the Georgia Constitution, and specifically the grounds for discipline that the Georgia Constitution authorizes. Article 6, Section 7, Paragraph 7A of the Georgia Constitution, Paragraph 7A, sets out 5 grounds for discipline: for willful misconduct in office, or for willful and persistent failure to perform the duties of office, or for habitual intemperance, or for conviction of a crime involving moral turpitude, or for conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. As detailed below, we agree with the hearing panel's conclusion that Paragraph 7A authorizes discipline against Judge Peterson for the counts discussed below because the director has met her burden of proving that Judge Peterson's conduct with respect to each of the 4 matters at issue constitutes at least one constitutional basis that authorizes discipline, either willful misconduct in office or conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. We then briefly review the hearing panel's findings as to the 8 remaining counts, counts 14, 15, 19, 21, 38, 41, 43, and 50, that the panel found were proven by clear and convincing evidence and warranted sanction. Although those findings are not clearly erroneous, we need not decide whether the hearing panel correctly concluded that Judge Peterson's conduct as to those counts constituted violations of the CJC and warrants discipline, because affirmance of those counts is not necessary to reach our ultimate conclusion that Judge Peterson's removal from the bench is the proper sanction in this case. Finally, after reviewing all of the conduct underlying Judge Peterson's numerous violations of the CJC, we assess the proper sanction. On that point, we agree with the hearing panel that removal from office is the appropriate discipline here. We now apply the analytical framework described above, beginning with an evaluation of the counts that the hearing panel found were proven by clear and convincing evidence and with which we agree warrant discipline. We address first the most troubling allegation: Judge Peterson's handling of a criminal contempt matter. A. Handling of a criminal contempt matter, counts 31 to 34. 1. The hearing panel's findings are not clearly erroneous as to the material facts pertaining to counts 31 to 34. With respect to counts 31 to 34, the hearing panel found the following facts pertaining to Judge Peterson's handling of a criminal contempt matter. On August 2, 2021, a petitioner who is a naturalized United States citizen but born in Thailand filed in the Douglas County Probate Court a petition to amend her marriage license application, which she had filed with the court in May 2016. The petitioner sought to correct the name she had listed as her father's name on the marriage license application. In support of her petition, the petitioner attached a copy of her birth certificate, which had been translated from Thai into English. The copy said that the document was not recommended as a legal document. After reviewing the petition to amend, Judge Peterson issued on August 12, 2021, a notice of trial or hearing, which informed the petitioner that she was required to attend an in-person hearing on her petition on August 24th, and that court reporting services would be provided only if the petitioner arranged for them. The notice made no mention of any charges of contempt and did not advise the petitioner that she was entitled to have counsel present. At the hearing on the petition to amend, which was not transcribed, the petitioner presented the copy of the translated birth certificate, and Judge Peterson concluded that it was fictitious, fraudulent, and forged. The petitioner explained to Judge Peterson that she previously had listed her uncle's name, rather than her father's name, on her marriage license application in 2016 because her father was not involved in her life and her uncle had raised her. Judge Peterson ultimately determined that the petitioner was trying to defraud the court and held her in contempt. The contempt order stated that the petitioner willfully provided false information on the marriage application. The court had been alerted to the fraudulent misrepresentations on August 2, 2021, when the petitioner filed a petition to amend marriage record, and the petitioner was, in blatant disregard of the laws of the state of Georgia and of this court, evidenced by her fraudulent misrepresentations to the court via her filings with the court. Judge Peterson sentenced the petitioner to the maximum allowable term of incarceration for contempt, 20 days in jail, but allowed her to purge herself of the contempt order after serving 2 days if she paid a $500 fine. After the petitioner served 2 days in the Douglas County Jail and paid the $500 fine, she was released from custody. The hearing panel found that Judge Peterson provided neither a firm nor a proper basis when she held the petitioner in contempt and, without explanation or justification, imposed the maximum term of incarceration plus a fine. It determined that the petitioner, who testified before the panel, was in good faith trying to correct what appeared to be an innocent mistake born out of ignorance rather than ill intent. The hearing panel noted that Judge Peterson testified that the petitioner sought to amend the marriage license application so that her mother could emigrate from Thailand to the United States. Although Judge Peterson could not explain how the amendment would assist the petitioner in obtaining emigration documents for her mother. Whereas the petitioner testified that she became aware of the mistake on her marriage license application while she was completing emigration documents for her mother, and believed she should correct the application so that it would not be inconsistent with her birth certificate. the hearing panel expressly credited the petitioner's testimony over Judge Peterson's. In addition, the hearing panel expressly discredited Judge Peterson's testimony that she had not concluded that the petitioner made fraudulent representations before issuing the notice of the hearing on the petition. In this respect, the hearing panel found that Judge Peterson predetermined that the petitioner had made a fraudulent misrepresentation via her filings with the court on May 3rd of 2016 before ever conducting a hearing on the matter. The hearing panel noted that Judge Peterson denied making any such predetermination and testified before the panel that she found the petitioner in contempt based on her submission of the supposedly fictitious birth certificate at the hearing on the petition, but the panel found that testimony to be false because it contradicted the plain language of the order, which referred only to the alleged fraudulent misrepresentations in the marriage application. Because evidence presented at the hearing supports the hearing panel's findings that are material to our ultimate conclusion, those findings, as recounted above, are not clearly erroneous. 2. Judge Peterson violated CJC Rules 1.1, 1.2, A, 1.2, B, and 2.2. The hearing panel concluded that the director proved by clear and convincing evidence that Judge Peterson violated CJC Rules 1.1, Count 31, 1.2, A, Count 32, 1.2, B, Count 33, and 2.2, Count 34 in connection with the contempt matter. We agree. To begin, the hearing panel credited the petitioner's testimony over Judge Peterson's account and found that, in attempting to amend her marriage license application, the petitioner was, in good faith, trying to correct an innocent mistake. After affording proper deference to that credibility determination, it is clear to this court that Judge Peterson's contempt ruling was baseless. In response to the petitioner's good faith effort to amend her marriage license application so that it would not be inconsistent with her birth certificate, Judge Peterson made an unsubstantiated finding that the petitioner was somehow attempting to defraud the court, and then unjustifiably held her in contempt. Indeed, the hearing panel determined that Judge Peterson, in testifying before the panel, lied about the basis for her contempt ruling when she repeatedly referenced her belief that the translated birth certificate was fraudulent, notwithstanding that her written contempt order focused only on the alleged fraudulent misrepresentations in the marriage license application, not the birth certificate. Judge Peterson's untruthful testimony in this respect underscores her conscious wrongdoing in determining that the petitioner had defrauded the court before issuing the notice of the hearing on the petition, because, as the hearing panel found, Judge Peterson purposely issued the notice without advising the petitioner that a criminal contempt charge on the allegation of fraud would be adjudicated at the hearing, so that the petitioner would be unprepared to defend herself when Judge Peterson summarily found her guilty of criminal contempt. As we explain below, these actions of misconduct evinced a willful disregard for the basic requirements of due process. It is well established that criminal contempt is a crime in the ordinary sense, and criminal penalties may not be imposed on someone who has not been afforded the protections that the Constitution requires of such criminal proceedings. In this respect, although a judge may announce punishment summarily and without further notice or hearing when contumacious conduct occurs in the judge's presence and threatens a court's immediate ability to conduct its proceedings, such as where a witness refuses to testify or a party disrupts the court. When the alleged contumacious acts are committed outside the judge's presence, due process requires that the alleged offender is entitled to more normal adversary procedures. Here, Judge Peterson's contempt order shows that her ruling was based on the petitioner's allegedly providing fraudulent information on her marriage license application. Conduct that necessarily happened outside Judge Peterson's presence, since the petitioner filled out the application and submitted it to the court more than 5 years before being ordered to appear for a hearing. And as discussed above, the hearing panel discredited Judge Peterson's testimony to the contrary. Even assuming for the sake of argument that the information the petitioner initially supplied the court was fraudulent, and also assuming that filing such information could warrant a sanction of criminal contempt, the petitioner's alleged conduct constituted indirect contempt at most, such that the petitioner was entitled to the due process protections generally afforded to other criminal defendants. Thus, before holding the petitioner in contempt, Judge Peterson was required to advise the petitioner of the contempt charges, provide her a reasonable opportunity to respond to them, and permit her the assistance of counsel and the right to call witnesses, among other processes and protections. As the hearing panel determined, however, Judge Peterson provided the petitioner none of these foundational due process protections before sentencing her to serve 20 days in jail. Even worse, the panel concluded that Judge Peterson decided that the petitioner had committed fraud on the court before she issued the notice of the hearing on the petition, and then purposely issued the notice in a way that failed to advise the petitioner that a criminal charge would be adjudicated at the hearing. As the hearing panel pointed out, the contempt order stated that Judge Peterson was alerted to the petitioner's alleged fraudulent misrepresentations on August 2, 2021, when the petitioner filed a petition to amend marriage record. Yet, Judge Peterson's notice of the hearing on the petition, which was issued 10 days after Judge Peterson was alerted to the alleged fraud, provided the petitioner no notice of the contempt charge such that the petitioner could obtain counsel or meaningfully defend against the charge before she was summarily found guilty and sentenced, noting that Judge Peterson testified that she knew the difference between direct and indirect contempt because she had previously researched the issue. The hearing panel determined that Judge Peterson knew the procedures she employed failed to meet due process requirements when she predetermined that the petitioner committed criminal contempt, issued the notice of the hearing without informing the petitioner that the criminal contempt matter would be adjudicated, ambushed the petitioner at the hearing by alleging that she had committed a crime, summarily found the petitioner guilty and sentenced her, and then lied about her actions in her testimony before the panel. Given these circumstances, we have no difficulty concluding, as the hearing panel did, that the director proved by clear and convincing evidence that Judge Peterson failed to comply with the law in violation of CJC Rule 1.1 by failing to provide the petitioner basic due process protections in a criminal proceeding, acted in such a manner as to severely diminish public confidence in the integrity and impartiality of the judiciary, in violation of CJC Rules 1.2, A and B, and failed to adjudicate the contempt matter fairly, in violation of CJC Rule 2.2. 3. Judge Peterson's conduct constitutes willful misconduct in office, such that discipline is authorized under Paragraph 7. A of the Georgia Constitution. Having determined that Judge Peterson violated CJC Rules 28 1.1, 1.2, A, 1.2, B, and 2.2, we now turn to whether the Georgia Constitution authorizes discipline for these violations. In its report and recommendation, the hearing panel found that Judge Peterson's actions regarding this incident constituted willful misconduct in office because she acted in bad faith. The hearing panel's factual findings that Judge Peterson's conduct involved bad faith are supported by the record and are therefore not clearly erroneous. Based on those findings, we agree that Judge Peterson's actions constituted willful misconduct in office and that discipline is authorized. We interpret willful misconduct in office to mean actions taken in bad faith by the judge acting in her judicial capacity. And, as we recently explained, bad faith generally encompasses at least two characteristics: that the duty breached by the actor was known to that actor, and that the actor was acting with some self-interest or ill will. It certainly must involve something more than negligence. Bad faith is not simply bad judgment or negligence, but it imports a dishonest purpose or some moral obliquity, and implies conscious doing of wrong, and means breach of known duty through some motive of interest or ill will. Here, Judge Peterson was clearly acting in her judicial capacity when she found the petitioner guilty of criminal contempt and sentenced her. And the hearing panel's findings that she was acting in bad faith are supported by the evidence presented at the hearing. The panel determined that Judge Peterson knew about the basic due process requirements for indirect contempt proceedings, a finding that is supported by Judge Peterson's testimony on that point. The hearing panel also concluded that Judge Peterson predetermined that the petitioner had committed criminal contempt well before she issued the notice of the hearing on the petition to amend the marriage record, yet she purposely issued the notice without informing the petitioner of any such criminal charge, and then summarily sentenced the petitioner without providing her any of the fundamental due process protections to which she was entitled. As the hearing panel noted, the plain language in the notice of the hearing and in the contempt order contradicts Judge Peterson's testimony that she had not predetermined the petitioner's guilt before she issued the notice, such that the panel was authorized to conclude that Judge Peterson's testimony in this respect was false and indicated that she was attempting to conceal her wrongdoing. This credibility determination by the hearing panel was based in significant part on its observations of Judge Peterson's and the petitioner's testimony during the hearing, and it is the kind of finding to which we offer considerable deference. In sum, the hearing panel's finding of bad faith with respect to Judge Peterson's wrongful summary adjudication of the criminal contempt matter is authorized by the evidence presented at the hearing, particularly her dishonest testimony about her wrongdoing. As we have explained, although we do not expect judges to be perfect, we can and do expect them to be honest. The judiciary has no place for dishonest persons, as the judiciary's authority depends in large measure on the public's willingness to respect and follow its decisions. Because Judge Peterson's actions were not merely negligent, but painted a picture of conscious wrongdoing motivated by ill will, we agree that her actions were taken in bad faith. Thus, Judge Peterson's conduct constitutes willful misconduct in office, such that paragraph 7A of the Georgia Constitution authorizes discipline for her actions with regard to this matter. B. Conduct toward county personnel, counts 28 and 30. 1. The hearing panel's findings are not clearly erroneous as to counts 28 and 3015. With respect to counts 28 and 30, conduct toward county personnel, the hearing panel found as follows. By way of background, in April 2021, the Chief Judge of the Douglas County Superior Court limited Judge Peterson's after-hours access to the Douglas County Courthouse following an incident in which she allegedly improperly admitted public citizens to the courthouse without ensuring that they had undergone security screening by sheriff's deputies. During the days in which her after-hours access to the courthouse was limited, Judge Peterson submitted 3 event worksheets, each of which requested 3 sheriff's deputies to be present at the courthouse after it was closed to the public so that she could have after-hours access. Specifically, she requested deputies to be present from 5 p.m. to 8 a.m. on April 22nd to 23, 5 p.m. to 11:59 p.m. on April 23rd, and 12 a.m. to 8 a.m. on April 25th to 26. Although these requests would necessarily require taxpayer-funded deputies to work overtime, Judge Peterson was unable to provide a particular reason why she needed to be physically present in the courthouse at those times, most of which were overnight. Although Judge Peterson argues in her exceptions that she often worked later than regular court hours and that her testimony on that point showed that her requests for after-hours access to the courthouse and the presence of security were legitimate. She also admits that the requests might not have been the most appropriate response. The hearing panel expressly noted Judge Peterson's testimony about these requests and found that Judge Peterson never put forth a particular reason why she needed to be physically present inside the courthouse on the dates and times she requested. In a separate event related to Judge Peterson's treatment of courthouse personnel, the sheriff's deputy who was scheduled to escort Judge Peterson from her chambers to her courtroom on May 11, 2021, did not arrive in Judge Peterson's chambers on time. Believing that she would be late for court, she pushed the panic button under her desk to summon the deputy. Thinking there was an emergency in Judge Peterson's chambers, sheriff's deputies hurried to her chambers. When they arrived, they realized that there was no emergency. At her hearing before the hearing panel, Judge Peterson testified that she did not know the button was a panic button that was to be used only in emergencies. The hearing panel expressly discredited Judge Peterson's testimony on that point. After reviewing the record and considering Judge Peterson's exceptions, we cannot say that the hearing panel's findings as to these incidents, which are supported by record evidence, are clearly erroneous. 2. Judge Peterson violated CJC Rules 1.2b and 2.8b. With respect to Count 28, the JQC charged Judge Peterson with violating CJC Rule 1.2b, alleging that her requests for after-hours court access and her activation of the panic button when there was no emergency were not in accordance with the high standards of conduct necessary to preserve the independence, integrity, and impartiality of the judiciary. And with respect to Count 30, the JQC charged Judge Peterson with violating CJC Rule 2.8b by failing to demonstrate patient, dignified, and courteous conduct to the county personnel involved in the matters discussed above. Based on the findings detailed above, the hearing panel determined that the director proved by clear and convincing evidence that Judge Peterson violated Rules 1.2b and 2.8b because her actions were not consistent with the high standards that Rules 1.2b and 2.8b require of members of the judiciary. The hearing panel determined that Judge Peterson made multiple frivolous requests for middle-of-the-night courthouse access without any showing that she in fact intended to be in the building during these times, and plainly without consideration of the taxpayer expense that comes with paying multiple deputies overtime for each such demand, and that she abused the courthouse panic button system when, losing patience after waiting only several minutes, she accelerated her deputy escort's arrival via that button rather than by phone or email. The panel found that Judge Peterson's actions raise grave concerns about her general judicial demeanor and the manner in which she treats others. We agree with the hearing panel that Judge Peterson violated CJC Rules 1.2b and 2.8b.17 by requesting sheriff's deputies to work throughout the night so that she could have after-hours access to the courthouse without any showing that she actually planned to be in the building, let alone work during those wide-ranging time frames, and using the panic button to summon a deputy to escort her to court. Judge Peterson did not demonstrate the decorum and temperament required of a judge. As discussed above, the hearing panel expressly found that Judge Peterson's testimony that she did not know the button was a panic button that was to be used only in emergencies was unconvincing. We defer to that credibility finding. We therefore agree with the hearing panel's conclusions that Judge Peterson failed to maintain the high standards required to preserve the integrity of the judiciary and failed to demonstrate a patient, dignified, and courteous demeanor to county personnel. Paragraph 7A of the Georgia Constitution. With respect to counts 28 and 30, the hearing panel concluded that Judge Peterson's conduct was in her judicial capacity and in bad faith, such that it constitutes willful misconduct in office. We agree. The hearing panel found that, with respect to Judge Peterson's requests for after-hours deputy coverage and her activating the panic button, she knowingly acted discourteously and impatiently in order to advance her self-interest. This finding is supported by the evidence presented at the hearing, including Judge Peterson's inability to explain during her testimony why she needed to be present at the courthouse for extended periods of time in the middle of the night, and her false testimony that she was unaware of the proper use of the panic button. The hearing panel also found that Judge Peterson summoned the deputy in bad faith when she pressed the panic button because she likely was motivated by ill will toward the sheriff's office after the incident that led to her restricted after-hours access to the courthouse. Because the hearing panel found that Judge Peterson's actions were not merely negligent, but were motivated by self-interest, and that finding is not clearly erroneous, we conclude that Judge Peterson's actions were taken in bad faith while she was acting in her judicial capacity, such that she committed willful misconduct in office. Thus, discipline is authorized for this conduct. 7A. Coomer C. HOA meeting, counts 13 to 15. 1. The hearing panel's findings are not clearly erroneous as to counts 13 to 15. With respect to counts 13 to 15, the hearing panel found the following pertaining to Judge Peterson's conduct during a meeting of her neighborhood HOA in March 2022. Judge Peterson, representing herself, filed a lawsuit against the HOA and members of the HOA Board of Directors in July 2021. The lawsuit alleged, among other things, that the defendants had breached the HOA bylaws by holding an improper election to select the Board of Directors and sought an injunction to compel a special election in accordance with the bylaws. Judge Peterson knew that the defendants were represented by counsel. On March 31, 2022, while her lawsuit was still pending, Judge Peterson attended an HOA meeting over which 2 members of the Board of Directors presided. The meeting was video recorded, and the recording showed that during the meeting, Judge Peterson asked the 2 members of the Board of Directors questions about her lawsuit, urged them to call a special election, and offered to dismiss the lawsuit if they did so. When other meeting attendees spoke out against Judge Peterson, she engaged in hostile exchanges and made sarcastic remarks toward them such as, "You are in a low place." After the meeting, Judge Peterson told the members of the Board of Directors that their counsel was giving them bad legal advice. The hearing panel's findings, as summarized above, are not clearly erroneous because there was evidence presented at the hearing to support them. 2. Judge Peterson violated CJC Rule 1.1. We agree with the hearing panel's conclusion that Judge Peterson's conduct in connection with this incident violated CJC Rule 1.1, count 13.19. The hearing panel determined that Judge Peterson failed to respect and comply with the law in violation of CJC Rule 1.1 when she violated Rule 4.2a of the Georgia Rules of Professional Conduct, GRPC, for lawyers, which says, "A lawyer who is representing a client in a matter shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law or court order." By telling the 2 members of the HOA Board of Directors that she would dismiss her lawsuit against the HOA and the board if they held a special election, Judge Peterson, who was acting as her own lawyer in the matter, communicated and even attempted to negotiate with parties to the lawsuit, even though she knew they were represented by counsel. As a result, she violated GRPC 4.2a. The terminology section of the CJC defines law as denoting court rules as well as statutes, constitutional provisions, judicial emergency orders, and decisional law, including the Code of Judicial Conduct and advisory opinions of the Judicial Qualifications Commission. The GRPCs are rules promulgated by this court, which presumptively brings them within the scope of court rules. And Judge Peterson makes no argument that the GRPCs are not court rules. Noting her testimony at the hearing that her comment about dismissing the lawsuit was not meant to be a formal offer, and that she did not actually believe that the two members of the board of directors had any actual authority to settle the lawsuit, because, as her lawsuit alleged, they were not properly elected, Judge Peterson asserts in her exceptions that she did not violate GRPC 4.2a because she was acting as a homeowner, not a lawyer, when she offered to dismiss the lawsuit. But the hearing panel rejected that version of Judge Peterson's testimony, expressly discrediting her feigned ignorance, and instead finding that she was an experienced attorney who knew that the lawsuit she personally brought was still pending and that the defendants were represented by counsel. We defer to the hearing panel's credibility determination and likewise conclude that Judge Peterson violated CJC Rule 1.1 for the reasons explained above. 3. Judge Peterson's conduct outside her judicial capacity was undertaken in bad faith and is prejudicial to the administration of justice, such that discipline is authorized under paragraph 7a of the Georgia Constitution. As discussed more below, a judge may be disciplined for conduct undertaken in good faith in her judicial capacity, if that conduct appears to be unjudicial and harmful to the public's esteem of the judiciary. But when a person who is a judge acts outside of that capacity, this court's ability to discipline the judge is more limited. In order for actions taken outside of a judge's judicial capacity to constitute conduct prejudicial to the administration of justice, and thus within our constitutional power to discipline, those actions must be taken in bad faith. Thus, as the hearing panel correctly noted in its report and recommendation, we may discipline Judge Peterson for her violation of CJC Rule 1.1 in connection with this incident only if her conduct was carried out in bad faith. In this respect, the hearing panel found that Judge Peterson breached a known duty because she testified that she was aware of GRPC's 4.2a and because the evidence showed that she was a prosecutor for several years and then an elected judge, and was therefore familiar with the GRPC. The hearing panel also determined that Judge Peterson acted with self-interest and ill will because she sought to exploit her specialized knowledge as a lawyer in surprise settlement negotiations with laypersons on an unlevel playing field to obtain the relief she wanted in her lawsuit. The hearing panel also noted that Judge Peterson's violation of Rule 1.1 was clear, and that her feigned ignorance and attempts to avoid responsibility for the violation in her testimony bordered on the farcical, severely eroding her credibility with the hearing panel. This express finding of bad faith, which was based in significant part on the panel's personal observation of Judge Peterson's testimony and the credibility determinations that flowed from it, is one to which we offer considerable deference. And because the hearing panel's finding of bad faith is supported by the evidence presented at the hearing, such that it is not clearly erroneous, we defer to that finding here. We likewise conclude that Judge Peterson's actions in communicating with represented parties about the lawsuit she had filed against them paint a picture of a judge who will bend the rules when it serves her self-interest, such that we can discern that her actions were taken in bad faith and that discipline is authorized under paragraph 7a. D. Handling of a petition for years' support, counts 35 and 37 to 43. 1. The hearing panel's findings are not clearly erroneous as to counts 35 and 37 to 43. With respect to count 35 and counts 37 to 43, the hearing panel found the following facts pertaining to Judge Peterson's handling of a petition for years' support in the spring and summer of 2021. In early 2021, a petitioner filed the petition for years' support, seeking to obtain funds from her deceased husband's estate. 22. The petition listed the petitioner's daughter as an interested party and provided her out-of-state address. Judge Peterson's chief clerk sent by certified mail, with restricted delivery, a notice of the petition to the address that was provided for the daughter. The notice set the deadline to submit a caveat to the petition by May 3, 2021. On April 5, 2021, the signature card for the certified delivery of the notice of the petition was returned to the probate court with a signature from someone else, not the daughter. 23. Judge Peterson's chief clerk then asked Judge Peterson to search LexisNexis to try to obtain an alternate address for the daughter. Judge Peterson conducted the search and found the daughter's email address. Judge Peterson's chief clerk emailed a second notice to the daughter, setting a new deadline to file a caveat by July 10, 2021. The daughter eventually emailed her caveat to the probate court clerk's office. The chief clerk and the daughter then spoke by phone, and the chief clerk asked about the status of the original document and the filing fee, which were both required for filing. The daughter said that she mailed the filing fee. The chief clerk assumed that it was lost in the mail and ultimately took payment from the daughter over the phone and filed the caveat on July 14, 2021, 4 days after the July 10th deadline. None of the chief clerk's communications with the daughter included counsel for the petitioner. The hearing panel found that although Judge Peterson's staff, including the chief clerk, knew that ex parte communications with parties to a proceeding were prohibited, Judge Peterson clearly failed to conduct proper oversight to ensure that the chief clerk was not participating in such communications. The petitioner's counsel filed a motion to strike the caveat as untimely, and Judge Peterson denied it. Judge Peterson later recused herself from the case, which was eventually transferred to Douglas County Superior Court. That court struck the caveat as untimely and granted the petition for years' support, about 15 months after it was first filed. The record supports the findings summarized above, so we conclude that they are not clearly erroneous. 2. Judge Peterson violated CJC rules 1.1, 1.2, A, 2.9a, 2.9b, and 2.9d. We agree with the hearing panel that the director proved by clear and convincing evidence that Judge Peterson violated CJC Rules 1.1, count 35, 1.2, A, count 37, 2.9, A, count 39, 2.9b, count 40, and 2.9d, count 42, in connection with her handling of the petition for years' support. We turn first to the alleged CJC Rule 2.9 violations. By accepting and considering the daughter's emailed caveat, of which the petitioner and her counsel had no notice, Judge Peterson permitted and considered ex parte communications in violation of CJC Rule 2.9a, and as the hearing panel noted in its report and recommendation, none of the exceptions listed in CJC Rule 2.9a that might authorize ex parte communications applied here. By failing promptly to notify the petitioner's counsel of the second notice of the petition that was sent to the daughter by email, with the extended deadline for filing a caveat, Judge Peterson violated CJC Rule 2.9b, and by failing to provide proper oversight to her own chief clerk, who sent the daughter the second notice of the petition and spoke to the daughter on the phone about the case, without notifying the petitioner's counsel of these communications, Judge Peterson violated CJC Rule 2.9d because she failed to make reasonable efforts, including providing appropriate supervision, to ensure that Rule 2.9 is not violated by court staff, court officials, and others subject to the judge's direction and control. Accordingly, Judge Peterson violated each of the provisions of CJC Rule 2.9 noted above. As to the other alleged rule violations pertaining to these counts, the hearing panel concluded that Judge Peterson violated CJC Rule 1.1 by failing to comply with Uniform Probate Court. Rule 5.1, which generally prohibits judges from initiating or considering ex parte communications with parties to a pending proceeding. The hearing panel determined that Judge Peterson also violated CJC Rule 1.2a because permitting and sending communications to only one of the interested parties in the case diminishes public confidence in the independence, integrity, and impartiality of the judiciary, and weakens the public's perception that the judge has afforded all of the parties the same right to be heard. We agree with the hearing panel's determinations in this regard. 3. Judge Peterson's conduct is prejudicial to the administration of justice, such that discipline is authorized under paragraph 7(a) of the Georgia Constitution. We agree with the hearing panel that Judge Peterson's inappropriate judicial actions taken in good faith, with respect to her handling of the petition, are prejudicial to the administration of justice and bring the judicial office into disrepute. Judge Peterson was acting in her judicial capacity in handling the petition and in directing or supervising her staff. As the hearing panel noted, even if Judge Peterson did not intend to favor one party over another, engaging in ex parte communications is inappropriate and unjudicial. We agree. Engaging in or allowing ex parte communications presents to the public an image of a judge who covertly interacts with a party in order to unfairly advance that party's interests and jeopardizes the appearance of the independence, integrity, and impartiality of the judiciary. Because Judge Peterson's inappropriate actions taken in her judicial capacity, even if undertaken in good faith, appeared to be unjudicial and harmful to the public's esteem of the judiciary, her conduct is prejudicial to the administration of justice, and discipline regarding these counts is authorized under the Georgia Constitution. Other alleged violations found by the hearing panel, which we decline to consider. In addition to the violations of the CJC that we determined above that Judge Peterson committed, and for which she may be disciplined pursuant to paragraph 7(a) of the Georgia Constitution, the hearing panel concluded that the director proved by clear and convincing evidence 8 other counts in the formal charges, counts 14, 15, 19, 21, 38, 41, 43, and 50. We briefly discuss below the hearing panel's findings, which we determine are not clearly erroneous as to these counts. But ultimately, we need not decide whether the panel correctly determined that the conduct underlying those counts constituted violations of the CJC or sanctionable conduct under paragraph 7(a), because the affirmance of those counts is not necessary to reach the conclusion that Judge Peterson's removal from the bench is the appropriate sanction in this case. As to Judge Peterson's conduct at the HOA meeting, the hearing panel concluded that Judge Peterson violated CJC Rules 1.2a, count 14, and 1.2b, count 15, when she repeatedly cut off homeowners as they attempted to speak, engaged in petty quibbles with them, mocked them, and used cavalier, rude gestures while communicating, because those interactions fell short of the high standards of conduct necessary to maintain the integrity of the judiciary. And as to Judge Peterson's handling of the petition for years' support, the hearing panel found that Judge Peterson violated CJC Rule 2.9c, count 41, which prohibits judges from investigating facts in a pending proceeding by researching alternative addresses for the daughter. The panel also found that Judge Peterson violated CJC Rule 2.5a, counts 38 and 43, which says that judges shall perform judicial and administrative duties competently, diligently, and without bias or prejudice, because her extension of the deadline to file a caveat and acceptance of the untimely caveat created an appearance of bias in favor of the daughter. Her actions led to a 15-month delay in resolving the petition, which was anything but diligent, and she incorrectly transferred the case to the Superior Court and then failed to ensure that the entire record was transmitted. In addition, the hearing panel made findings as to a separate incident involving Judge Peterson's conduct in allowing a party to a wedding over which she was scheduled to preside to enter the Douglas County Courthouse while the courthouse was closed, without ensuring that the party underwent security screening by sheriff's deputies, in contravention of an express directive from the Division Commander for Court Services with the Douglas County Sheriff's Office not to allow the party inside. Counts 19 and 21. The hearing panel ultimately concluded that Judge Peterson violated CJC Rules 1.2b, Count 19, and 2.5b, Count 21, which says in pertinent part that judges shall cooperate with court officials in the administration of court business because she violated the courthouse security protocol and the division commander's directive by allowing civilians to enter the courthouse without required security screenings. And finally, the hearing panel concluded that Judge Peterson violated CJC Rule 2.4a, as alleged in Count 50 of the formal charges, by persistently and continuously failing to respect and comply with the law, and the CJC, as alleged in Counts 16 through 49 above, demonstrating systemic judicial incompetence and a disregard for the law. CJC Rule 2.4a says, "Judges shall be faithful to the law and maintain professional competence in it. Judges shall not be swayed by partisan interests, public clamor or intimidation, or fear of criticism." The hearing panel found in its report and recommendation that the director had proven this count by clear and convincing evidence based on all the findings of fact and conclusions of law above, as well as the pervasive nature and expansive temporal scope of Judge Peterson's misconduct. The hearing panel's factual findings with respect to counts 14, 15, 19, 21, 38, 41, 43, and 50 generally are supported by the evidence presented at the hearing. But we need not decide whether the hearing panel correctly concluded that Judge Peterson's conduct violated Rules 1.2a and b, 2.5a and b, 2.9c, and 2.4a, as alleged in those counts, or whether discipline is authorized under Paragraph 7a for any or all of the conduct at issue, because the affirmance of those counts is not necessary to reach our conclusion that Judge Peterson's removal from the bench is the appropriate sanction in this case. 3. Removal is the appropriate sanction. We have determined above that Judge Peterson violated 8 provisions of the CJC, as charged in 12 counts. CJC Rule 1.1, Count 13, in connection with her communications with represented parties at the HOA meeting, Rules 1.2, B, Count 28, and 2.8, B, Count 30, in connection with her conduct toward county personnel, Rules 1.1, Count 31, 1.2, A, Count 32, 1.2, B, Count 33, and 2.2, Count 34, in connection with the criminal contempt matter, and Rules 1.1, Count 35, 1.2, A, Count 37, 2.9, A, Count 39, 2.9b, Count 40, and 2.9d, Count 42, in connection with her handling of the petition for years' support. We have also determined that discipline for Judge Peterson's violations of these rules is constitutionally permitted, because her actions constituted willful misconduct in office or conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. The hearing panel noted in its report and recommendation that the violations at issue here, when viewed individually, likely would not warrant the sanction of removal from office. We agree, but the hearing panel also determined that Judge Peterson's misconduct related to the contempt matter was troubling and discordant with one of the judiciary's primary purposes, to provide due process to all who come into court, especially when one's freedom is at stake, and that her pattern of misconduct related to the many other matters exhibits a persistent unwillingness to apply to herself the rules that apply to everyone else. In particular, the hearing panel's findings, which we have determined were not clearly erroneous, show that Judge Peterson acted in bad faith in her judicial capacity by willfully disregarding the petitioner's basic due process rights in the criminal contempt proceeding, which portrays to the public an image of a judge who believes she is above the law. And the hearing panel's findings that Judge Peterson acted in bad faith outside her judicial capacity by knowingly communicating with represented parties at the HOA meeting present a comparable image. The hearing panel's findings similarly establish that Judge Peterson acted in bad faith in her judicial capacity toward county officials when she requested sheriff's deputies to be present after regular courthouse hours, including overnight, and when she activated the panic button in her judicial chambers. And although Judge Peterson possibly acted in good faith by permitting the ex parte communications with respect to the petition for years' support, her misconduct demonstrated a failure to comprehend and follow the law, which in turn causes prejudice to the administration of justice. As the hearing panel determined in recommending her removal, Judge Peterson's misconduct has already demonstrably eroded the public's respect for the judicial system. And regardless of the extent to which the hearing panel considered the mitigating evidence that Judge Peterson offered at the hearing and emphasizes again before this court, we conclude that such evidence is not particularly persuasive, as the instances of misconduct at issue here spanned nearly the entirety of Judge Peterson's judicial career. Moreover, the hearing panel's determinations supported a conclusion that Judge Peterson was disingenuous, if not outright dishonest, during the JQC proceedings, because she provided untruthful or evasive testimony with respect to, among other things, her conduct regarding the HOA meeting and the courthouse wedding. The hearing panel noted in this respect that Judge Peterson falsely testified that she made no recording of the events that took place at the HOA meeting, pointing out that the video recording of the meeting that was admitted into evidence at the hearing showed that she held up her cell phone, indicating that she had in fact recorded the meeting. It also noted that Judge Peterson's attempts to avoid responsibility for violations related to the HOA meeting severely eroded her credibility with the hearing panel. The hearing panel also found that Judge Peterson falsely testified that after the division commander told her not to take the wedding party into the courthouse, the sheriff overrode that directive and granted her permission to enter the courthouse to perform the wedding ceremony, because the hearing panel fully credited the sheriff's testimony, which flatly contradicted those assertions. In addition, the hearing panel expressly concluded in other sections of its report and recommendation that Judge Peterson lied during her testimony, including when she claimed that she had not predetermined that the petitioner was guilty of criminal contempt before she issued the notice of hearing on the petition, when she stated that she was not aware of the purpose of the panic button, and when she feigned ignorance about communicating with represented parties at the HOA meeting. As we recently explained in determining that another judge's disingenuous, if not outright dishonest, testimony during the JQC proceedings informed our decision to remove him. A judge faced with an ethics investigation by the JQC has every right to defend himself. He can argue that his actions do not violate a particular statute or rule, including the Code of Judicial Conduct. He can disagree with JQC staff or the hearing panel as to appropriate sanctions. He can dispute the factual accuracy of the allegations against him. And judges must be free to do all of those things without fear that a sanction will be worse if they simply fail to prevail. But judges cannot be misleading during that process, any more than lawyers can be misleading during state bar disciplinary processes. As in Coomer II, the hearing panel in this case found multiple instances in which Judge Peterson attempted to mislead the panel by falsely testifying, indicating her desire to conceal her misconduct. Because those findings are supported by the evidence at the hearing, we consider them as an aggravating favor in determining the proper sanction. In conclusion, in light of her multiple violations of the CJC rules in relation to several matters, some of them reflecting a flagrant disregard for the law, court rules, and judicial conduct rules, the pattern of violations that the director proved by clear and convincing evidence, the extremely concerning nature of some of those violations, in particular with respect to the criminal contempt matter, and her behavior during the JQC inquiry, we conclude that removal is the appropriate sanction. Accordingly, it is ordered that Judge Christina Peterson of the Douglas County Probate Court be removed from office, effective upon the date of this opinion. As a result, Judge Peterson shall not be eligible to be elected or appointed to any judicial office in this state until 7 years have elapsed from the date of this opinion. Removed from office. All the justices concur, except Colvin J., disqualified.